Thank you so much for joining us today for our presentation on Litigators' Guide to Collaborative Practice. My name is Shanza, and I'm an articling student at Russell Alexander Collaborative Family Lawyers. I have the pleasure of introducing today's panel and also be here throughout the webinar in a supporting role for our presenters and audience members. Russell is joined by seasoned family law professionals and collaborative practice experts. We have Jonathan Paynter, Carrie Heinzl, and Brian Galbraith. Before I share some background on our presenters, I am going to take a moment to let you know what is on today's agenda. While I do that, we would also like to hear from our audience to get to know our viewers a bit better. So we will start with our first poll. And in the meantime, I will let you know what to expect over the next hour. Our panelists will be sharing their insights on collaborative practice, covering the following topics. What the heck is collaborative practice? CP teams and dealing with impasse, in and out court, family-operated companies, the CP community, how to get CP clients, and then we will end off with a Q&A session. We'll ask that everyone please keep in mind that the content of this webinar is to provide you with general information on separation and is not to be considered as legal advice. It is now my pleasure to introduce today's hosts. From the Greater Toronto Area, we have Jonathan Paynter, Carrie Heinzl, Brian Galbraith, and Russell Alexander. Jonathan Paynter is a registered social worker and psychotherapist who works in the family court system, completing custody and access assessments, parenting capacity assessment, and youth court assessment. He specializes in cognitive behavioral therapy, couples counseling, and holds certificates in collaborative family law, advanced family mediation, family arbitration, domestic violence screening, offender relapse prevention, and actuarial assessment of risk. Jonathan is on the board of directors of the Ontario Association for Family Mediation, holding the executive position as secretary of the board, as well as being chair of the accreditation and the course approval committees. We have Carrie Heinzl. She's the founder of Fairmore Family Law Financial Solutions. Fairmore offers independent, fact-based financial analytics and settlement insights to individuals and couples working through separation and divorce. Carrie is an active collaborative process trainer, co-teaching the introductory program for new collaborative professionals and advanced level training for seasoned practitioners. Carrie has taught statistics. She has presented at conferences for the Ontario Association of Collaborative Professionals, Family Dispute Resolution, Institute of Ontario Annual Conference, and the International Academy of Collaborative Professionals. Next up, we have Brian. Brian is the owner of Galbraith Family Law, which has 6 offices in Ontario and 16 collaborative lawyers. Brian is the president of the International Academy of Collaborative Professionals and has served on its board for several years. Brian has helped train hundreds of collaborative professionals and conducted workshops on the international stage. Brian has served on the board of the Ontario Association of Collaborative Professionals and was instrumental in its formation. Brian was chair of the Trainers Committee in Ontario for several years. He continues to serve as the president of his local practice group. He is also a mediator. Lastly, we have Russ. Russ is the founder and senior partner at Russell Alexander Collaborative Family Lawyers. With 25 years of experience, he uses his knowledge and expertise to serve his clients in all aspects of family law and helps them cope with the difficulties of separation and divorce and other family matters. He uses experience to create unique solutions for each client to enable them and their families to move forward and support them through the transition of divorce and separation. Russell has written 3 books on separation and divorce and is a fully trained collaborative practice lawyer. He speaks at conferences on collaborative practice, marketing, technology, and the law. Thank you to our speakers for being here today. I will now share the results from the poll, and I will let Russ take it away from here.
Thank you for those kind words, Shanza. Brian is also the president of the IACP, and we're going to have some information about a new book on AI in the legal profession coming up. But let's see who our audience is. Family lawyer professional with 60%, different area law lawyer 15%, another field 18%, going through a separation, navigating a family matter 3%, law students, 2 law students today. We love to have law students join us. So let's make a start. And Shanza, let's also run our second poll. Please participate in the polls. It helps us understand who our audience is, and we can tailor our content accordingly. If you have questions, send them in. We're going to go through questions throughout the program. We have already received a bunch of questions in advance. If you want to learn more about collaborative practice, Shanza will put into the link a link to CP 101. You can get a much deeper understanding. We're doing a high-level overview today with the focus on litigation tips for CP, for litigators. So I threw this slide in here. Oftentimes, when we think about litigation lawyers and collaborative lawyers, sometimes they're in two different camps. Some people refer to litigation lawyers and their clients as arsonists, or they think of themselves as warriors. By contrast, collaborative lawyers sometimes are viewed as peacemakers, or sometimes they're referred to as firefighters. So this is sort of the dichotomy. We're going to be giving litigators our tips on collaborative practice, what you should know, what you can take away from it. Let's run our second poll while we're still fresh into this. And what we want to know is, are you a CP trained professional? Just to gauge our audience. And we did have an audience question that came in while we're waiting. This is joining a CP organization worth the cost? Well, Brian, what do you think of
that? Absolutely. There's different organizations that you can join. I encourage everybody to join a practice group, and that's a local group of professionals that are doing this kind of work. And the reason it's beneficial is, well, for example, this morning we were just heard the great Carrie Heinzl and others do a presentation on Zoom about the client experience. And so you have an opportunity to learn and bond with other collaborative professionals in your area. So a practice group is an important thing to join. But also, I'm president of the IACP, and when I joined that organization, it took my practice to a whole different level. And the reason for that is because I was connecting with collaborative professionals from around the world and learning about their experiences, learning about how they get through tough cases. And so I found that it really improved my ability to represent clients. And more than that, it makes you feel like you're part of a community. And so it's encouraging because, oftentimes we're toiling away all by ourselves in our practices. And it's so wonderful when we realize that we're part of a worldwide community of people helping others get through their separation and divorce. So I think it's very beneficial. You make connections, it'll lead to more cases, and you'll improve your skills, and you'll just feel better about practicing as a peacemaker.
We're going to learn more about the IACP forum that's coming up in a few weeks, but just a follow-up question, Brian. For our audience, how do you find a local practice group? Like, what are the steps to going, all right, well, I practice in, say Durham or Barrie. How do I find the group? What do you do? Just a Google search?
Well, I think the best source is if you search Ontario Association of Collaborative Professionals, and that website has a list of all of the practice groups. And so, I'm a member of 3 different practice groups. I'm president of our local group, and then I'm a member of the York Region Collaborative Group and also the Toronto Collaborative Group. So go on to there, see what group is in your area and join and go from there.
And that's quite common. I think I'm 3 or 4. Carrie, how many groups do you belong to?
I belong to 2 right now.
Jonathan?
I'm in 3. And being a family professional, just to add very quickly to what Brian said, it's a great way to meet people, and it enhances your practice because I don't just get referrals about collaborative cases now. I get
Yeah.
voice of the child reports. I get psychotherapy referrals. So knowing all the lawyers and other family professionals and financial professionals in that group has been so great for to grow my practice in other areas, not just collaborative. So making those connections is key.
Let's throw our poll results up there. Just a quick story. I know just after I got my CP training, I was in motions court. Typical day in the trenches. This is old school in person. Remember that pre-pandemic. And the collaborative training made me a better litigator. This lawyer's coming at me. We're doing a spousal support motion. And I said, easy breezy. You don't need to be adversarial with me. And she kind of looked at me like a deer in the headlights. That's all she knew, right? Just taking a position. And I said, what are your client's goals? What are her interests? What does she want to accomplish today, right? And oh my God, it completely changed the dynamic of the conversation, her attitude. We worked at a resolution, even though it was a contested motion. And so as a litigator with the training, you approach files differently. And in my view, from a better mindset. Let's see what our audience is saying. Are you CP trained professional? 18% yes, 80% no. Okay, well, we've got some details on how you can get training coming up, so stay tuned for that. And we also have an offer to get a copy of the most recent book, Artificial Intelligence in the Legal Profession. But that's just a teaser. Hang in there. This is going to go by quick. What the heck is collaborative practice? Okay, Brian, take it away. High level talking point. We could talk about each one of these for an hour, but we're doing a quick overview. You want to learn more, we'll give you a link to learn more. Brian?
Collaborative practice was started by a gentleman named Stu Webb in Minnesota. And what happened is he had a really brutal custody access trial. And at the end of it, he said, you know, I'm either going to find a new way to practice law or I'm going to quit practicing, because he felt he really hurt the family, hurt the children. His relationship with the other lawyer was harmed by the whole trial process, and he just felt like, you know, I became a lawyer to help clients. I didn't become a lawyer to hurt families. I want to help. So what can I do to help? So he said, you know what? I'm just not going to go to court. I think that the court system is set up for battle, and I don't think that's beneficial to families. And so that was his commitment. He on January 1st, 1990, he committed to no longer going to court. And that changed everything. Changes everything because it says that you are deeply committed to coming to an agreement, and that if the matter goes to court, you're out of a job. And so that changes the mindset of the lawyer and everybody involved in the case, because we're no longer just setting up the case for litigation. We're not prepping for litigation. We're not positioning ourselves for that stage, because if the case goes to litigation, we're not going to be involved in it. Now, having said that, not every case is appropriate for collaborative. Probably 5% of cases are involve people that need to hear from the judge. But in the vast majority of cases, we can help through the collaborative process. So the first thing that we do is we sign what's called a participation agreement. And the participation agreement is a legal contract that the parties sign at the very beginning of the process. And it has a whole lot of information about the process. We call it the vessel. It really contains the process and creates the process. And the hallmark of that is the disqualification clause. So that's a clause that says that if this matter goes to court or to arbitration, that the professionals will not be involved in those adversarial processes. And that's, I think, the best part of collaborative practice, because it really engages everyone completely in helping the clients come to a settlement. But it also has other elements to it. It says that everyone's going to have full exchange, full disclosure of all information. We're not going to take advantage of any mistakes. We're not going to do anything to harm the other person. We're going to treat each other with respect. We're going to keep the children as our priority if there are children involved. So it really changes the way that the issues are looked at by the parties. It says we're going to work together to find a solution. So it's an interest-based process. So what that means is that we're not just putting forward our position. I want, for example, a position is something that can only be answered with one solution. So an example would be, I want to sell the matrimonial home. Well, the only way that can be satisfied is if the matrimonial home is sold. So that's a position. And we lawyers are taught to take positions and justify it with as much evidence and argument as possible so that we might get our client's position. In collaborative practice, we go deeper. We ask, why do you want to sell the matrimonial home? Why is that important? So the answer might be, well, I want to get a home for myself eventually, and I need the financial resources. Oh, okay. So now we have lots of different options for settling the case for the client. We could, and that's what we're trying to do, is we're trying to create an opportunity where we can come up with lots of options for the clients. And then we find out what the interest.
Brian, what if they say, well, I just don't want the other spouse to have it?
Right. Then we start to dig into that. Right. Why don't you want the other spouse to have it? And what's going on there? Because of course they're fueled by emotions, and it's an emotional experience.
There's another underlying interest there, right?
Yeah. And in collaborative practice, we work with mental health professionals, which we call the family professional, who have the skills to understand the emotional journey that the clients are going on. And so they can look at those things from a different perspective that we as lawyers are not trained in doing. People like Jonathan can help clients understand clients in a way that we just don't get as lawyers. And but they'll also be working with a financial professional who is a neutral, like Carrie, and they'll be able to look at all of the finances as a neutral person and help them come up with options for settlement and help them even negotiate those settlements so that everyone can move forward. One of the advantages of working with a financial professional is that they have so much more knowledge about the finances than lawyers. So the process is all about privacy and full disclosure. So everything that takes place in the collaborative process stays there. So for you lawyers out there, it's a without prejudice negotiation. So the participation agreement says very clearly that anything that's disclosed in the process stays in the process. Now, of course, there are elements that should the matter break down and it have to go to another process such as court, of course you're going to disclose tax returns and RSP statements and all those fundamental pieces of evidence. But offers made, discussions made and discussed stay in the collaborative process. I've already talked about the disqualification clause. That's key. And it's a key element because it really creates a vested interest of the professionals to make sure that the settlement is achieved if at all possible. Next slide. The law is applicable in a collaborative case, absolutely. But in litigation, the way I think about it is litigation, the law is like the sun, and the world rotates around the sun and the focus is on the sun. It's the priority and the most important thing that is considered for litigators, because that's the legal model. We're before a judge, asking the judge to apply the law to the facts of our case. That's our role. That's our job. In collaborative practice, we recognize that divorce is multifaceted. there are a lot of other considerations other than the law. So the law is more like a star in the night sky. It's an important factor, but it's one of many important factors. Sometimes it's the other factors might be emotional issues or his issues related to the children going forward, or issues so that people might choose to deviate from the law, but we as lawyers are still helping them understand the context in which they're making decisions. So I love doing collaborative practice cases. I find it personally rewarding because I feel like I'm really helping clients through a difficult time in their life. And I love working with a team, with the neutrals, who can help me do better and help me achieve a better outcome for the family. So I love it, absolutely.
Thanks, Brian. Is Stu going to make it to forum? Do you know, Stu Webb?
No, Stu is not. He's getting pretty old. He said he doesn't travel, but we're going to have a little video of a message from Stu Webb to share with everyone, because he doesn't get on an airplane anymore.
The master, great guy. We have a question about how getting more collaborative. Somebody just graduated, wants more training. Hang in there. We're going to tell you about collaborative practice training. It's coming up. We're going to get to CP teams and impasse in just 1 second. I just want to add 2 things. Using the financial professional saves money, right? The traditional litigation model is the lawyer, the law clerks prepare the briefs, and then we send letters back and forth saying, oh, you're missing this and that. Then we bring a motion to argue the matter. Then we realize, well, the other lawyer did provide it, and I just didn't read the file properly. And thousands of dollars are flushed down the toilet, right? But with the financial professional, you get one brief prepared for the whole team. All the documents are there. Super fun. The other thing I want to do, and I'm going to screw this up, and Brian, you're better at this than I am, right? So this is the whole person. This is how much your family knows about your divorce. This is how much your lawyer knows. This is how much your lawyer understands. This is how much your lawyer presents to the judge. This is what the judge takes in. I know I'm not getting it wrong, but the point of collaborative practice is so the judge gets this little tiny bit of who you are.
And to finish it, Russ, is that the judge makes a decision based on that tiny cube at the end that you had. And go ahead.
Collaborative, you got the whole person, right?
Right.
Is that what you're going to say, Brian?
Yeah, that's absolutely right. You know, in the end, as lawyers, as you know, it ends up being a small piece of the client's experience that the judge focuses on and makes decisions based on that, those facts, and it just misses 98% of who that human being is, and that's not any fault of the judges. They're all well-meaning people, most of them, and they're trying their best to help people resolve their issues. It's just the fact that process ends up, that the judges have limited opportunity to really get to know the people.
Well, let's speak to the litigators in our office, right? In our audience. We've all had these cases, right? The thing's almost done, right? You're down to the pots and pans or something, and somebody says, I want the vacuum cleaner, and the other one says, no, I want the vacuum cleaner, and then the other spouse says, well, they don't even have any carpets in their house. We're thinking, this is stupid, right? You could have bought a vacuum cleaner for the amount of money you're paying me to argue over this. It's not about the vacuum cleaner. And the family professional is going to help you understand why this vacuum cleaner is going to send the case off the rails. So litigators, you can, using these tools and these experts really help out. All right, I'm getting a little bit too excited here. Carrie, CP teams dealing with impasse. What do we need to know?
Well, what you need to know is that CP teams are amazing. So that's the first thing you need to know is the thing about CP teams is the right person doing the right job for the right price. So the idea is that our wonderful lawyers, everybody went to law school. Some of you might have some financial training. Some of you probably don't. Most of you probably don't. So, and then on the emotional side of that, you don't get trained in these areas. So the idea is for your clients, what's great is if you have a financial person doing all of the finances, you have a family professional dealing with your parenting plans, communication issues, you've got the right people doing the right jobs for the right price. The thing that's great about using a financial professional and a family professional is the costs are shared. Therefore, you're lowering the cost of the entire process instead of in a traditional where you have your legal counsel arguing back and forth, getting positional. Now what we can do is for the financial professional, one agreed to statement of fact is going out. For the family professional, they're drilling down, getting that same idea where it's an agreed statement of facts of how they want to do their parenting. And I always say the reason for a really good family professional like Jonathan, especially if you have kids, is that I don't know about you guys, but when I had my children, the hospital forgot to give me the manual on actually what to do with them. So I found that really rude.
There's a manual?
Apparently I didn't get it. But if you're going through this process and you get a really good parenting plan, it's like having an owner's manual to parenting. It's one of those things where all of a sudden you're like going, hey, wait a second, we have a problem. We're at impasse. How do we get past this? Oh, wait, Jonathan told us how to do that. It's right here. How awesome is that? I would like to have had an owner's manual. I didn't get one. Just saying.
Yeah. And I think too, another thing to add to your comments there is, you have all three experts working in their area of expertise. So you have the financial person who's a financial expert doing that work. The lawyers are legal experts. They're doing that work. The family professionals, the family experts, so they're helping out with the parenting plan. And because I provide this service as a social worker, so my services are not taxable. There's no HST to use me. And a lot of people can claim my time on their benefits as well. So for a lot of people, it doesn't cost them anything. And I can help work on the parenting plan, which, otherwise they would have to pay both lawyers to do. So it can be really cost effective.
We had a question come in about prerequisites for training. We're going to answer your question. There's more coming up on training. Just hang in there. But what I really love about the process, the effective teams that I've been on, is they introduce the professionals at the front end. Even before the first meeting, they're working with the financial. Again, there's a closer together. They're working with Jonathan or other family professionals. They're working on a parenting plan. So by the time you have your first meeting, you may have a draft parenting plan ready to discuss. You may have a draft financial brief and homework items of it's just such a fantastic process.
It's about being high value. That's the whole point, is that those meetings are expensive. Meeting with lawyers and trying to hash something, that gets expensive. So you want it to be high value. So everything that we're doing, it's about the family. It's not about a process.
You don't need two lawyers to figure out if little Johnny's going to get dropped off at school Monday morning or go home Sunday night. Jonathan can work that out. You're saving thousands of dollars. But
we're all working at the same time, Russ, so that the parenting plan is getting done at the same time the financial piece is getting done, and the lawyers can work on the actual separation agreement in the meantime, so that when you come together, you have all those pieces already. And otherwise, you have one person, your lawyer, working on all those things in sequence, and they may not have a lot of time to do it all. So having three professionals working on your case instead of one, it really saves a lot of time.
And I'm talking to the litigators in our audience right now. We all know these seemingly, which to the lawyers seem like simple things, end up in motions court. We blow off thousands of dollars, arguing about pickup time, drop off time, get a professional like Jonathan involved, neutral, coming up with creative solutions. It's fantastic. In and out of court. Sorry, go ahead.
One thing I wanted to say is I used to do litigation, and I enjoyed it. I've done several trials, and they were exciting and fun, and I enjoyed the whole process. But win or lose, my clients didn't ever seem to be happy, and that's why I turned to this process, because the clients just seem to walk away from the litigation process unhappy, and I'm like, what am I doing if I'm not helping people and they're leaving me unhappy? It just doesn't make sense.
Well, Brian, you're giving them a voice. They have a chance to be heard. They don't get heard in court. They want to hear from the lawyer, not the client. If they hear from the client, the lawyer is going to get in trouble from the judge. And secondly, they get to tell their story, right? Sorry, Carrie, I know you want to jump in here. Go ahead.
Yeah, one of the things I just wanted to point out to our litigators in the audience is that most of your family law judges now are collaboratively trained and had successful collaborative practices before they became judges. And what we're seeing in my office is I'm getting a lot of judges now saying you need to go to a financial neutral to deal with your finances. They're no longer going to put up with that. I didn't get my disclosure. I need another extension. They're not putting up with it. They're saying, no, you're bogging up my, you're wasting my time. Get out, go and see a neutral to get this done. And they're doing with parenting plans as well. So they're saying, so if you have a judge saying to you, get a family professional, get a financial professional, it's because they have been collaboratively trained. And if you're going along with it, they're going to know that you are actually wanting to be collaborative and you want to do what's best for the family.
Take it one step further, the Divorce Act changes require us to explore resolution outside the court system. The first question the judge is going to ask the litigators, what steps did you take to resolve this? And most of the judges know the professionals, right? They'll say, go see Jonathan Paynter or Carolyn McAlpine or another professional. Go work out your parenting plan. If you can't figure it out, come back to me. So they'll send you home before you get a result. All right, so each one of these, Carrie, you know, we can talk a day about each one of these points, but runaway train that's coming up at the forum. It's coming up at Family Law Summit, 3-4 weeks. You can learn more. Real quick, high conflict.
I think everybody should go to the Family Law Summit.
Yeah.
Sorry.
Runaway trains. What are you talking about?
Runaway trains, they are matters. They have been in the courts. They may have been in there for years and years and years, and it's going nowhere. Pull it out and bring it into collaborative. We have done this on numerous cases where it's just not going anywhere. We get everybody in a room. They have their voice. They can be heard. And I'm just always shocked by how surprised the clients are, where they're like going, well, I didn't think they would ever agree to that. When we were in court, they never even considered this. And now all of a sudden they're agreeing to this. And it's kind of like, yeah, because they're being heard. You know, it goes along with, litigation fatigue. Your clients had enough. Pull them into the collaborative process. If we need to modify a collaborative agreement to get them in, we'll modify it so that you can go in. Sometimes it has to be modified. And we'll talk about that either a little bit later, or we can always talk about that in another seminar or webinar, but pull them out. They don't have to stay there. You can actually put your matter on hold in the court and say, hey, we want to try it in a collaborative manner. We're hopefully never going to be back. I don't think I've ever heard of a judge going, no, that's a bad idea.
I've had cases come to me after 2 years of litigation, $100,000 in legal fees, nowhere close to settlement. And I explain the collaborative process to these clients and they say, nobody told me. I didn't know there's another option, right? So we pulled exactly what you say, Karen. The runaway trains, these high conflict cases, there's no doubt. They destroy family wealth and relationships and children. But you have an opportunity to bring it up, bring this train into the station, settle the case collaboratively. And it's a hard sell sometimes, right? So this is when we talk about directed purpose, and I get some heat from other collaborative professionals because I do this. Occasionally we'll modify the participation agreement to get the parties into the process. 2 examples. One, the wife was refusing to do it collaboratively because she thought there'd be issues about disclosure. And so we included a provision saying the matter could be returned to court just to deal with the issue of disclosure. Well, lo and behold, it never went back to court. That issue was off the table. We went into the CP process and worked out and settled. Another example was we were having problems getting third-party disclosure from a corporate officer. Shares in the company had gone up post-separation. The wife thought they're up to mischief that the contract was delayed. The corporate officers were not giving the lawyers that they needed the information that they needed. Again, we carved that issue out. We said you can return it to court to get an order directing these parties to produce the disclosure, which we did. We got the information, the case settled. those are exceptions. Most pure CP lawyers don't want to play around with the participation agreement. We find it's effective to get these runaway trains into the collaborative process. But let's talk about family operated companies. So Carrie and I and others have presented on this. We call it saving the golden goose. You get it. We're taking a deeper dive at the Family Law Summit in a couple of weeks. You'll learn some more. But family operated companies are kind of a unique item, right, Carrie? What do we need to know about this, and how can collaborative help?
Absolutely. The very first thing you always want to know about a family-owned company is, what is the structure? So is this a structure where it's a corporation? Does a husband and wife own shares? Do any of their kids own shares? Are there any other outside people that are actually owners of the corporation? Knowing structure is your absolute first move for this. When we know the structure, and this is anywhere in a collaborative file, not just people that have a business, it's about, do we need to bring in another expert? Sometimes, like I am one level of a financial professional, I'm not a certified business valuator. I have a couple of companies that I do a lot of work with. So I would say, listen, let's get a CVV to come in and value this company. Do we need to get an income determination with that as well? What we want to do is we want to see, how do we make sure we preserve the company so that everybody's getting what they need out of it? We need the company you actually have to look at as another entity within the myriad. And that it's not just something that you can say, well, let's just sell it, divide it, and not be done with it. That will destroy the family. This is something that is a living being in the sense that it is providing, usually for the entire family, and usually generationally for families. You got to watch that. You've got to be careful with it. You don't want to kill it. You want to see, how can we manage it, and how can we get creative in doing so?
Yeah, and just a litigator's tip, keep in mind, divorce is tough on business owners, right? You're distracting them from focusing on running a successful business. A lot of businesses fail because of the divorce process, psychologically, financially, emotionally. So collaborative is a great setting for your clients who own businesses. And I just want to say one quick thing about extended or extra large teams. We've had very wealthy families where we've brought in corporate lawyers to help us with corporate structuring, tax lawyers to help us with tax efficient way to transfer assets, estate lawyers to help us with legacy planning. So if a partner repartners, we don't want that new partner affecting the business operations or the other spouse's interest. So you do this issue identification, which you don't get in court, of all these professionals coming together and brainstorming what's the best way for us to complete this divorce and division of property and continue to save the golden goose so this family provides for generations to come. Because oftentimes there's adult children working in these companies as well. So it's not just the couple that's affected. All right, the CP community, we've got getting lots of questions about this. Let's talk about training, because that seems to be a popular question. Jonathan, you want to take the lead here, and then we'll get Brian to talk about the groups a little bit more informed.
You want me to talk about the training?
Please. How do you get training?
Yeah, so people who have a background in family law, like lawyers, mental health professionals like social workers, psychologists, and so on, financial professionals, we can all take the training to become collaborative professionals, because it really requires a fresh mindset, and it's going to be very different from how all those professionals handle their other cases. So training usually is about a week, a full week. Sometimes it's broken up into half days here and there, but if you add it all up, it's about 5 days of training, and it involves, learning from both all the professionals, the lawyers, the financial people, the family professionals, and it's a really engaging course. I took the course with Brian and Carrie and Russ were the instructors, and it was just fantastic. There's a lot of case studies, so you get practical experience of how to deal with these situations, and it's a really great way to expand your practice, no matter what kind of professional you are. So I highly recommend the training. You learn so much more, not just about collaborative, but also how to work with complex family law cases. And as you said, Russ, it's not just good for your collaborative practice, but it can be good for other areas of your practice as well.
Yeah, it makes you a better.
So I highly recommend the training. And in Ontario and Canada, I think in general, you need a certain number of hours to count. In the US, they require less hours to count. And once you've got that training, then you can join your collaborative practice groups and start getting referrals from your colleagues and making connections in your local group.
Yeah, and it also makes you a better litigator as well, for the reasons I discussed earlier. So Brian, we talked a little bit about local practice groups, OACP, IACP. What are these organizations? What does our audience need to know?
Well, yeah, Russ mentioned collaborative practice training helps you be a better lawyer, a better professional. Frankly, it improved relations all around with my family and friends, because I just became a different person after I learned about the interest-based process. And so you do actually become improved as a human being. So Ontario Association of Collaborative Professionals, that's not something you need to become a member of. You are automatically a member of that in essence when you join a practice group, because the members of OACP are the practice groups. So you join a local practice group, and then your practice group is part of the OACP. IACP is the International Association of Collaborative Professionals, International Academy of Collaborative Professionals. And so that is something that you have to become a member of. And then you have access to the resources from around the world. You have access to webinars on a monthly basis, seminars on a quarterly basis. And then you can come to the forum. And that's what the next slide is. The forum is our international conference. And we are so lucky that it's in Toronto this year, because it goes all around North America, and hasn't been in Toronto for about 20 years. So this is coming up October 19th to 22nd, and you can still register for it. So there's full day pre-forum institutes. And this is one of the things that people may not be aware of. You can just register for one of those institutes if you're not able to come Friday and Saturday to the conference. We've opened it up so that you can take the full day, that's an advanced training. So if you've been trained and you want to take your practice to another level, you could come to the institute. The conference itself is at the Western Harbour in Toronto, and it's Friday and Saturday. There's 33 different workshops that you can take, and they're with trainers from around the world. We've got, including some of the people you see on this screen. You've got cutting edge training, to really help you get better at your practice. And people, one of the comments that people always make about the forum is you leave totally energized and excited, because you're sitting at tables with people from around the world, and you're getting to know what they're doing and their experience. And you realize that there are thousands and thousands of collaborative professionals around the world doing this kind of work, and all wanting to make it a better world. We're truly there to help people get through a really difficult time in their life. And so you go away from the forum just feeling excited and energized. We have a big keynote speaker, Dr. Brian Goldman from CBC fame, is speaking about teamwork. It's a great thing. So if you want to, we'll send the link to everyone tomorrow, and so that you can, if you want to register, please do. Right now, I think our registration numbers are at 321 people from right around the world.
Yeah, and you forgot the most important part, Brian. It's so much fun. Like, it is just fun. I love every year I've gone. I've had a blast every
It's
year.
in person.
We have a day.
Everybody's really excited. They have a gala dinner and dance where everybody gets dressed up on the Saturday night. It is just a fantastic way to meet people from around the world who are interested in the community.
Okay.
So let's see who's attending. We got 9% coming. Great. 47 no, and people want to learn more, 44%. We're going to have a link for the registration for form that we're going to provide to you. We're also going to give you a link for training and a special discount. And we're also giving you information about that book, Artificial Intelligence.
What a discount, Russ? What's that discount?
Just for this week only, Artificial Intelligence and the AI legal profession. So we're going to get to it. Just hang on. But let's do another poll. Throw the next poll up. All right. This is the important stuff. This is the pro on forum. What's the best party at forum? Meeting colleagues in the lobby bar. As soon as you walk,
Yes.
you meet people as you're signing up to get your hotel room, right? Like you're getting a room key and you're already meeting people as soon as you walk into the hotel. Dine around dinner. So they have special restaurants that we've reserved where you can go out for dinner with collaborative colleagues. The gala and dance. Oh my God, fantastic. And others. So let's just do a quick poll here. Brian, what's your favorite?
Oh, for me, it's the dance, man. It's so much fun. And yeah, I'll be on the dance floor.
It's nice to get people dressed up, see people dressed up too, in person. Carrie, what's yours?
I liked it when we were all meeting at the lobby bar. We've had so many good conversations and so many good laughs at doing that over the years that's absolutely my favorite. But I gotta ask, Brian, is there a theme this year for the dinner, for the gala dinner?
Well, it's all about the future, and I can't remember the proper theme, but it's all about the future. That's what it is.
Are you wearing a space helmet or anything?
No.
The Martian from
Yes.
Simpsons.
Yeah.
The lobby bar, right? You get the chance to debrief from the day and learn what other people learned, and that's a learning process too, right? Just communicating some of the lessons you learned that day. Jonathan, your favorite part of forum?
Well, my favorite part is that I'm going for the first time in October.
Okay.
I've never been before. I've been to the Family Peacemakers Conference that happens every year. That's the joint OACP, OAFM, so the family mediators and collaborative professionals come together for the peacemakers. So I've been to that a few times.
I'm surprised you remembered attending that conference.
Hey now.
All right, our audience
Goes on in peacemakers, stays in peacemakers.
Carrie, I think our audience is on our side. 55% colleagues at the lobby bar. I love it. Come grab an elbow and we'll have a drink together if we see you guys down there. Dine around stuff.
Absolutely.
That's a great way to have sort of more intimate conversation with a smaller group of people. A gala dinner, like Brian said, super exciting and a lot of fun. I'll put it in the box. We'll take a look at it. All right, so this is what we're talking about. IACP, 3-4 weeks away, Toronto. We're going to give you the information if you want to sign up for it. It's a blast, a great way to network and meet colleagues. All right, one more. Let's get some more tips going, and then we're going to go into Q&A. So how do we get CP clients, right? Okay, I'm going to get the training. How do I find a client, right? We're running a business here, right? We've got to pay the rent. We've got to pay our assistants. We've got to pay our taxes. So let's just do a quick rapid fire roundtable here and get everybody's feedback. 1 or 2 tips. Brian, how do you get clients?
Well, I think it's when we have them in our consultations, we need to show leadership and direct them to collaborative practice. So I think that's the best way, is to explain to the client why collaborative practice would help meet their goals. So you need to first understand what your client's goals are, what they're hoping to achieve, and then you explain why collaborative practice will help them achieve their goals. So it's in the consultation that you get with clients.
But when you get the training, we also train you how to get clients, right? There's a session just on how to develop your business.
There's hours on that because it's so important.
Yeah.
And there's a lot of techniques that we share. The secret sauce, Russ.
Yeah.
How to open collaborative cases.
All right.
A lot of my cases, though, come from the neutrals. So maybe
Right.
Carrie and Jonathan could talk.
Jonathan, one or two tips how to get clients.
So when clients come to me for family mediation, that's probably the best way for me to get them involved in the collaborative process because as a mediator, I can help them in isolation, but I always explain to them it's better to work as a team, and then you have all the experts working on your case at the same time. So that's really how I sell the process to new clients.
Gary, quick tip.
Honestly, getting new clients is easy. I get them from everywhere. Absolutely, completely everywhere. I talk about CP and what I do because you get asked at different times. And I have been getting x-rays, talked to the radiologist while I was getting x-rays of what I did, gave him my business card, and he became a client. So, honestly, everywhere and anywhere you can get a CP client, no problems. You just need to learn how to talk about it, how to sell it. They come every which way. No problem.
Honestly, Carrie, I think the process sells itself because when you start explaining what it's like for people to go through it, most people realize that it's a much better process than the other options. And, there's definitely challenges to collaborative practice, but having the team come up with creative solutions to all those problems is such an advantage. And remember, this process was designed specifically to help families. The court process was not designed specifically to help families. It evolved into helping families, but it was really designed to resolve property disputes. So when you kind of explain it to people, I think it really sells itself.
Right. And I've met lawyers who haven't done our training, and they said, I've got trained, I haven't had one file. So getting it on these teams and meeting neutrals such as Carrie and Jonathan, they start referring you work. When I meet new clients, this is the process I tell them that we're taking. I don't give them options. I'm saying we're going to do it collaboratively unless I don't think it's appropriate. And if they want to learn about court, I'll tell them about court, and I'll explain why I'm recommending the collaborative process. So we're going to go to some Q&A now. Thank you, everybody, for that. But before we do that, Shannon or Shanza, let's just go to those slides real quick where we talk about the training process and where we talk about the summit. So training, we put a link in the chat box. Our next training session is November 13. Oh, back it up one. November 13. This is all by Zoom, so you can do it from your office or home. We're offering this special discount for this audience only, 10% if you sign up. We don't do this. 10% if you sign up by 5 p.m. Friday. So our program's almost full. I think we're over 20 now. In our course, we have a few spots remaining, and if you want to sign up, those are the dates, the links in the chat. We'll send you show notes. The second thing I want to talk about briefly before we get to Q&A is our Family Law Summit. This is coming up October 26 and 27. 2 days of material you can get. If you're a lawyer, you can get all your CPD credits at this summit. It's free. Doesn't cost you anything. So you're not spending $500-600 in training with the Law Society or some other group to get your credits. So look for that. We've got a bunch of issues we're talking about: AI, DEI, domestic violence, voice of the child, bankruptcy. We covered it all. And let's go to the next slide here real quick. What do we got up? All right. So we have an early bird for the summit, and we don't do this often. If you sign up for the Family Law Summit, that's by October 21st, you'll get a free copy of my next book, AI in the Legal Profession. So this isn't for sale to the public yet, but we will be giving you a digital copy of that. So look for that. We're going to put information in the link, but let's get to Q&A. How do you convince clients the process is less expensive? Carrie, how do you tell
You know what? It's an easy convince because it is less expensive. It is actually, I'm going to take that back. It's better value for money. Some people will know the cost of everything and the value of nothing. This is about value. And when it comes to that, it ends up being less expensive. Again, because you have the right professional doing the right job at the right price. Knowing that your neutrals are a shared cost really reduces the cost for everything going on.
Okay, rapid fire Q&A. We're keeping our answers short. Next one, is it okay for law students and art students to take collaborative practice before they get called to the bar? Yes, we have articling students in the program right now. Why can't professionals continue to be involved if the case goes to court? Brian, real quick, what happens?
Well, if you are able to go to court, then you're less invested in the settlement of the process. You know, when I was doing litigation, every litigation case started out being a negotiated process that broke down. We reached an impasse. We gave up and we went to court. But in collaborative practice, you don't give up. Because if you give up on the case, you're going to lose your client. So you're going to do your utmost to settle the case. Now, the clients, of course, always have the right to go to court should they want to after the process, but they're not going to do it with the professionals who help them in the collaborative case. So it really turns the whole process upside down, and it makes it all about getting the case settled.
All right. Are there any matters that are not appropriate for collaborative practice? Take the training. We're going to teach you about this. My view, I think we could just about do any case collaboratively, but there will be a handful. We'll talk about that in the training. What is the difference between a position versus a goal and interest? This is a hard concept for a lot of people, especially lawyers, to grasp. Ryan, 30 seconds or less.
A position only has one solution. An interest has multiple solutions. That's how you define it. So you say, okay, what is this? I want to sell the matrimonial home. Well, that's a position because the only way you can satisfy that is the matrimonial home is sold. But if your goal is to provide the financial resources to get a second home, well, there's lots of things. You can sell the home, mortgage the home, liquidate other assets, borrow from other people, rent accommodation. There's lots of solutions. So that's an interest.
Okay, I'm going to jump ahead real quick. Can I practice without belonging to practice groups? Yes, you get your training, you start practicing the very next day. So let's bring our host back on because we're top of the hour. Carrie, you want to jump in there real quick?
Yeah, the only thing I will say, but absolutely you can practice collaboratively without being a member of a practice group. However, getting matters and getting referrals to matters from your colleagues is a whole lot easier when you are a member. We get to know who you are, we know what you're all about, and it gets exciting for us to get and do a file with you. So join those practice groups because it's a lot of fun.
I agree. I'm just answering the question. Top of the hour, we're going to some more information here. Shanza, bring this into the train station. We're going to see everybody at Forum. We're going to see you guys at the summit, and we're going to see you in the training session. But what we need to know, Shanza.
Thank you so much, Russ. Thank you, Jonathan, Carrie, Brian, for joining us for this discussion today and sharing your experiences and insights. Also, I want to say thank you for our audience for tuning in and joining us today.